Hi everyone, welcome to ArtsFest Online and welcome to this afternoon's session, Intellectual Property and Photography, Creators, Owners and Licenses. If you have any questions as we go along, just pop it in the chat or the Q&A box and we'll go through them at the end. Just a quick reminder that this event is being recorded, and as it is a public platform, please don't share any confidential information. So I just want to hand over to the lovely Dr. Metka Potočnik, who will be presenting to you this afternoon. So welcome all, and welcome Metka, and over to you.
Thank you, Claire. And it's been traditional so far in these workshops that if there are certain forming questions as we move along, we invite everyone to participate. And usually that means I start putting Claire on the spot and ask her questions that artists should know answers to. And then everyone else is welcome to join in. You're not under any obligation, of course not, but it just makes for a more interesting exchange. Today we're focusing on photography and some select concepts around that, or specifically to copyright law. You will see the outline as well that I will share. But we would just invite you all that we do have already 2 recorded sessions where some of the other copyright concepts, key concepts around, for example, infringement, when do you take too much out of copyright and so forth. So there are 2 webinars that are already available on YouTube. So you might want to look at those as well if you have a specific, or just ask a question and we might signpost you. And Claire has confirmed she has also kindly embedded that in Canvas. So for any student with us today, you have a very easy access to this as well. So in a way, while I start clicking my way through to start sharing the presentation, if you do have any starting questions or any observations, let us know. Claire, can you just confirm that you see it in a proper way? So full screen, not presentation mode? Perfect, thank you. So we will now jump in today. So this is the third. So the first one was just sort of a general overview around copyright. I think we might have even touched on some of the other intellectual property rights. Then on the 4th of May, we had a session around fine art, focusing on questions like a statute or, what is art? Is the current approach to categories of protected art and other types of work obsolete, traditional, or just not fit for purpose? And we were looking into concepts around what will be an infringing copy. So what is a step too much, imitation, as opposed to inspiration, and all of us just sharing the cultural environment around us and the cultural commons that we should all be freely dipping into when we're creating new works. Now, today we're focusing on some specific concepts, and yes, the focus is on photography, but as you will see, there will be more general questions also around authorship. And I found, so there was a very interesting case in January that speaks to a number of different creative areas where you would have traditionally this notion of one creator, and they will always be given authorship and protection. So professional writer, or in this case, the professional photographer. But what happens with the team that is working with them and perhaps doing a little bit more than just, assisting with the technical aspects? So where is that line between, just technical stuff, or between somebody just popping in an idea or something, and actually joint author who might be deserving of some rewards from the resulting work? So we'll look at the question around joint authorship, and there has been a case in this year really in front of the courts. So I just thought it might be interesting to see those few points from there. And then we'll go back to our favorite topic of online use and images online. So I'll just sort of signpost to some of the questions. And again, I will signpost also the resource of Creative Commons. So when in doubt, that is a very practical solution to your engagement with materials online. So not only is Creative Commons a possibility for you to signal the terms and conditions to the general public of how your work can be used, so you can decide to attach a Creative Commons license to your own work. But even if that's not your cup of tea, even if you don't go down that route. Creative Commons also has a very usable database that you can then source materials from. So if you wanted to use a picture, such as I did, I don't know, I was searching for something that would relate to myth or myth busting, didn't find anything. So I just went for something a bit more hazy and sort of a little bit nondescript, but that's what I found on the database. And in my notes, I do have the full license. So this is Rocks by Americodias, is licensed under Creative Commons license BY-NC ND 2.0. So I do have all those rules in there that will also inform and make me as the user confident that what I'm doing is something that I can be doing, right? I'm not going to say that I would be reproducing this in books and selling it in thousands of textbooks, but in the current environment, I am safe. So the overview of what we're doing today is sort of general points and focusing in the beginning around photographs. What is a photograph and what will be an original photograph worthy of copyright protection? But I wanted to start first with, because this is something that popped up when I was doing some writing, the myth busting. So this is a very helpful list of 8 myths you might have heard of before, or statements around rules in copyright that you might think are right, but are actually not. They're myths, right? So I think this is a nice checklist to perhaps have always with these kind of webinars, or, you know, when you're discussing, do you know why this particular statement is correct or not, or do you want to know more about it, right? So for example, if we look at the first one, you can use a copyright work without permission as long as you're not making money from its use. We know from webinar the last webinar, so 4th of May, that is not true. You will need permission to use copyright protected works unless one of the defenses is available to you. The fact that you're not making money is not a requirement for copyright infringement to occur. The second one also is around registration. We covered those rules. We said in the UK, you don't have to register copyright. As soon as the work is created and it meets all the conditions from the statute, from law, you will get copyright protection, and so forth and so forth. Okay, so this is a list of 8 myths. Some of them have already been addressed in the first 2 workshops. I will, depending on time, I don't want to start with them and then sort of, you know, monopolize the time. I wanted to leave them here, and I think while I was blah, 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 going on and on about them, I think most of you were probably able to go through the list, but I will return to this list. So if you have one which you really, really want an answer to, we can come back to that at the end. So this list of 8 myths is reproduced at the end, and we can close with this particular list of myths. Claire, I'm just checking for your facial expressions if we have any burning questions at this stage. No, we're good. I can read also so I know you were trying to find the unmute button. You're good. I can read where we are. Okay, so what is a photograph? What is an original photograph? And you might think that this is such an obvious question, but actually I've been talking to an artist who says that her photographs, because she has a different approach to photographs and also sometimes mixing mediums, have been seen as some of the artistic community as not a photograph, might be some kind of other artistic work, but not a photograph. So this really piqued my interest to say, well, is it really that clear cut that a photograph is a photograph is a photograph? And this is really where I would open the floor, because I'm assuming that people who are in today's room will either know something about photographs, or they are into photography, or maybe they're lecturers or students, or, you know, there's an interest at least there. What I will start with is that historically in law, it was difficult to show that they are worthy of protection because they were seen as slavish imitations of real world. You know, not exactly like a Xerox machine would just copy something that you put on the screen. So just to make a copy of it. But really, if it's a portrait, it's really just a depiction of, what is real life. So that was historically the approach, but of course this is not approach today and hasn't been for many years. But still we see questions. So in the US, there was a question around, there was this research project where a researcher set up all these cameras. I think it was in a jungle, but it was definitely in a forest type environment. And then monkeys were taking selfies. It was just the setup was there. And then after some time, there were monkeys taking pictures, a selfie. And obviously then there was a question around that, because who can commercially exploit that image? It would be the copyright owner. And the question in front of the court then ended up being, is Monkey the author, the photographer of that picture, of that photograph, and thereby the copyright owner? And of course, at least in the UK, we haven't had a monkey case yet. But what we can say is that the approach of the courts would be, you have to have this human interaction. So an author is a human being, right? What does that mean for artificial intelligence type, or, if you have computer type software arrangements, it is whoever has put all the arrangements in place for that photograph to happen, they will be the copyright owner in that specific case. But without going into what the courts thought a photograph is and when it should be protected, is there any controversy? Is there any room for discussion what a photograph is nowadays? Is there any question around mediums, photographs taken by phones? Is that in any way problematic? Any interventions from the floor being the virtual room of Zoom?
Okay, Manos has said, or asked rather, what about security cameras, etc.?
Yeah, exactly. What about it? I have answers on slides 2, 3, 4, so coming up, but I want your opinion. So you're the artist in the room, right? I'm the lawyer. I'll give you the legal answer, or at least the extent to which it exists. But that's exactly right. What about CCTV? Right, all that, if you were to take a still shot from a CCTV recording, is that something that you would want to protect under copyright? Okay, so let's have a chat around a photograph. So if you go on, what is the course called, Claire, the photography course? Is it just photography?
That's a really good question. Maybe someone here in the room could correct me. I'm pretty sure it's, let me just check. I'm not entirely sure.
I don't mean to put you on the spot, Claire. I just see you, and that's why I pick on you all the time. But I was hoping for others.
I don't mind being picked on. It's all right. I think it's just photography, actually.
Mm-hmm. So we do have, I think we have, so the last comment was around, if I made a collage, does it represent the definition of photography? Well, I don't know, does it artistically? I'm really keen on, when you go into a photographic course, what is a photograph? Is that even discussed? Does anyone know? And it's not a test, I'm just curious by nature. That's why I do these things, I want to learn as well. Or maybe I'll leave you with that, and hopefully I'll have some reflections on that in the chat, right? We did have a question also around getting permissions from people who appear in your photos. I mean, those are the ethics. So I've had a chat again with a photographer, and her practice is very extensive. And she said, that because she's also teaching that, not here, but elsewhere. And she said that they teach something that's called ethics in any photography course. And I wanted to get materials for that, but there wasn't something as tangible. So do we have, Claire, do we have any of our lecturers here today?
Let me have a look who's participating.
Yeah.
Let me see if I can recognize any names. No, I don't recognize any names. There's a couple with initials. So
to answer the question, and that's why you have this, actually you have this conflict in the field of photographs. You might have heard of, they're not scandals, but there were reports around different models and even actresses using photographs of themselves, so a portrait, but they were not obviously the ones taking the photograph, right? So copyright in the photograph was owned by somebody else. So there was that conflict between the person who was in the photograph and the copyright owner, and she lost every single time. I mean, there were settlements around those type of cases, but you don't have to ask permission. Based on copyright, you don't have to ask for permission. Now, you will have certain exceptions and moral rights attached to you, and I'll just point that at the end. So if you sort of commission somebody to photograph something that's deemed in for private or domestic affairs, and that goes for films as well, the use and there are very severe restrictions on what can be done with that material. But apart from that, you just walking along in the street, you will own copyright in any picture you will take, unless you're doing that in and you're employed. So we'll come to that as well. So we have something from James as well, Claire, if you see it. So it's a two-dimensional digital representation of the real world taken by any sensing element, UV, IR, human visible light, and so forth and so forth. So very interesting observation as well. Should it be something that we can observe with the naked eye, or, you know, thinking about photographs in space, so with different telescopes and other things, or under microscope, or, you know, in light that's not visible to the human eye. So I think for the most part, as long as it's a human being or the photograph is the result of human effort, so somebody is behind a process that results in a print, whether it's a digital representation, and I understand that maybe I'm just too lawyery, so digital representation might be not the reference to a digital output, because we do still have, I think, photographs then being printed in certain cases as well. I think for the most part, a definition of photograph is quite similar to what a layperson would understand a photograph to be. But if you do have experimentations with people perhaps mixing mediums or referring to something as photograph, which is more interdisciplinary, or mixing different expressions, not just traditional photograph, that, you know, even if there's some challenging around in the discipline saying, oh, that's not strictly a photograph, it would be either a photograph or another type of graphic work in terms of the law, right? Photograph is usually physical, although with a digital photograph, again, it depends. But usually that was not the barrier for legal protection. So where photographers had problems, usually, was with not the medium itself, so there are photograph, because photograph is listed as a graphic artistic work in the act itself. So it says it's on the list, photograph. So that hasn't been really a problem. The problem was, is photograph original or expressive enough or worthy of copyright protection? So just like I started first, that historically it was difficult to find protection was, you know, well, literally you're just taking of something that exists in the world. You're just making a copy of that, a representation. So one of the key cases we had in Europe was the case of Painter, and it had to do with the photograph of a missing girl. So it's a portrait photograph. And the question there was, isn't that just a depiction of the person themselves? And the court said that, you know, as with any other work worthy of protection, you need to first search for, is this an intellectual creation that is the author's own and it reflects the author's personality? So there are no default rules around photographs excluded or included. Just like you wouldn't have default rules for any other type of work. Music in, you know, books out. There's no set rules. So just like, and we discussed the standard originality, I think, in the workshops, at least on the one on the 4th of May. So when will this happen? When will, at least in law, when will work be considered to be an intellectual creation? This will be the case if the author is able to express their creative abilities in the production of the work by making free and creative choices. And you will understand that within your own practice, what that means for you. So CCTV, do we have many creative choices? No. Okay, good. I see some faces. I mean, I'm not saying you can manipulate the image afterwards, but that would be a different setting, right? So in this particular case, and the reason why I've reproduced how the court has approached a portrait photograph is for you to, so you're thinking with an artistic head, and now I'm just sort of putting the word of the court in front of you to see whether this makes sense or not, and I'll be checking in with you, right? So they're first saying it's possible, even with a portrait, it's possible, and we know that really well, that there are creative choices in how you will portray a person. And actually, it's one of the reasons why people will go to a certain photographer and not to another, and why all the passport photographs are complete and utter. Introduce your own word that you want to, and I'm not allowed to because this is recorded. And then, so what happened in this particular case, right? So what are these creative choices that the court saw important in the process of taking a photograph? So already in the preparation phase, the photographer can choose the background, the subject's pose, and the lighting. When taking a portrait photograph, they can choose the framing, the angle, view, and the atmosphere created. Finally, when selecting the snapshot, the photographer may choose from a variety of developing techniques, the one he wishes to adopt, or where appropriate, use computer software. Is there anything missing on the list? Is there something that you as photographers, you do that the court didn't really include here in this personal touch? Do you think that you're doing something in your practice that is characteristics of your personal touch as a photographer that is missing from here, from the description? How you get ready and everything.
And Metka, there's a question in the chat, and I don't know if you want to touch on this just yet, or you did mention about interdisciplinary, work.
Yeah.
If I made a collage, does it represent a definition of photography?
It's a collage, so it's different expression, right? So the reason why I say that is that collage is actually one of the separate categories listed in, but again, it depends, right? Collage is something, but what if you were to take a picture of that?
Yeah.
Wouldn't it then be again transformed into the medium of photograph? And so I think this is the type of answer that you will be better placed to answer. I think when in doubt, what courts will do is they will ask the experts. So everyone else but me in the room today. So all the artists. Is that a photograph or is it a collage or nothing of the sort? But usually it will fall somewhere within the graphic arts work. One of the cases I think we had a look at together was, remember Claire was talking about the Oasis setup for the album photo shoot, and what they had was they had a car in the pool and they had some instruments by the side of the pool and the band members were everywhere. So that setup was something that they couldn't protect, because the journalists came into the bushes, took a picture of the setup, and then they ran away to their newspaper publisher and published that, and sort of did the scoop of something that later was the album cover. So the setup itself wasn't protected under copyright because it didn't fit within. So it wasn't considered to be a collage because it wasn't fixed, because it was static, it wasn't considered to be dramatical work, and so forth. So those type of cases we've had.
Okay, so Manoj, I hope that I'm pronouncing your name correctly. So for example, if I set up a camera in the woods with a motion trigger to shoot owls, is that a creative choice or something else? I choose a lot of things, but the moment was self-selected.
Yeah, and if that's part of the creative process, definitely, right? But we know that if you only have a security camera, which is triggered by movement, those images are probably not original photographs. So if it's every time something moves, but if you place it in a particular, so, you know, it goes back to the photographer can choose the background, the subject's pose, the lighting. So where in the forest, how will the owls go past, you know, anything else in terms of creative choices. But again, the description is there in front of you. It depends on whether or not the author, the photographer has put a personal touch in how they have set up and taken and selected the photograph itself, but it will depend on each case individually, definitely. So nothing missing from the list? This would be so much easier, Claire, right? If we had these people in the room and then we could do like a survey.
I know. It's not that, is it?
Or if they were law students, I could at least, you know, say, oh, but it's going to be on coursework or something. Anyway, okay. This is just us begging for attention and interaction. Don't mind us.
Okay. Jane says, I might select the clothing the model wears.
Yeah, absolutely. So, but is that so the appearance of so beyond subject's pose, there might be more involved, right? You might even think of an entire setup, the scenery, when you're sort of, it's not just, so with a portrait, even with a portrait photograph, yes, you might have an entire scenery behind it and so forth and so forth. Yeah, colors of the furnishings and so forth. So all these creative choices. So the courts were clear to explain that there's plenty of personal touch that a photographer can leave in their photograph, but it depends on each individual photograph whether that's happened or not, right? And another case that we've then seen in the UK, and it was decided after this case, is this a red bus against the black and white background of the Westminster Bridge and Houses of Parliament in the back, right? So what happened was that you had one party taking a picture of that, manipulated the picture so that only the bus remained red and everything else was sort of switched into black and white. And they've printed this photograph on mugs and keychains and all sorts of things. Then another competitor came along and manipulated the picture a little bit. So it didn't look exactly, it wasn't an exact reproduction, but it was still a red bus crossing the Westminster Bridge and the Houses of Parliament in the background. Now, your own impression, should this be stopped or not? So you see what is in front of us. Is this something that is original? And you can see how the court explained what this person trying to get protection did with the photograph. So the photograph of the red bus traveling across Westminster Bridge with Big Ben and a House of Parliament visible in the background. The photograph had been taken by this F, a director of the company that sued, and the resulting image had been manipulated using proprietary software. In particular, so what are these creative choices done? In particular, F has strengthened the color of the bus, made the rest of the image monochrome, removed the sky and some of the pedestrians, and altered the perspective of the image. Thinking again to what is a photograph, is this something you would want to protect and stop everyone else doing the same type of thing? Or is there such a thing as the same type thing? Or so we have James saying that it's a unique image. I want more answers, fewer questions, but I do like the engagement there. So if I took the photo 2 minutes later with a different bus, is that unique? Well, see, it's not just a picture of a bus, is it? So going back to what has been in front of the court here is, yes, it's a picture of a bus, but then it was manipulated by software. And then there were certain things done with the presentation and the image. And again, this is not a case that everyone agrees with in terms of the outcome. Some people thought it was rightly decided. Some people thought that it was going too far. Okay, maybe by a vote, who do you think should win? The person that took this picture or everyone else? You can put it in the chat. The shooter.
So Alexis says there's an element of plagiarism in this case, I think. Yeah, it's quite mixed. It's a really tricky one, isn't it? I don't know how I feel about that, to be honest.
I mean,
yeah, Nina says, wouldn't you have to copyright the stages of creation in order to be able to claim they are yours?
Well, I don't really understand what is meant by stages of creation. The only thing I can offer as a starting point is that copyright protects expression of idea, not idea itself. So what do we mean by stages of creation? Are we talking about different outputs? So, because, you know, there was copyright of Photoshop.
Photoshop. Right.
You know, again, each individual output can be judged for its own merit. So is it original enough? So maybe when you first have the medium of whether it's Lightroom, Photoshop, whatever, you upload the raw image, and then at which stage will you have your final output that you've decided has creatively met your expectations? You know, you could question that it comes down to evidence, whether people will believe you when you say, I've done this and this and this and this, but that I think is a technical aspect you can show in terms of the processing that was done to an image based on what's available in the app. You wouldn't necessarily have to demonstrate exactly how you come to it, but it's the whole point. If they are your creative choices, you will be able to explain them. All art these days is plagiarism, as it's all techniques being done before even the paintings. And that's why we have campaigns such as Creative Commons and a lot of discussion around that. Definitely a point to take away. London Bus, Houses of Parliament, other things are often seen as iconic London images. So how is the photographer of this picture an artist? I love the very loaded term of artist. So unless you're starving, you can't call yourself an artist, and you know, you need to be revered in some. I think there's different ways of viewing this particular category, but I think what the law will say is, as long as you meet the threshold of an original photograph, and remember, originality, we said it's author's own intellectual creation. So thinking about the personal touch, the creative choices, you will get copyright protection. Whether or not that qualifies this particular photographer as an artist, I will not make this judgment, right? And in a way, I don't know if I'm getting in trouble in this, but I think art is quite subjective anyway. I do think that, you know, there's something to perspectives. We all have different perspectives. Should I end the suspense? I'll tell you what the court said. Sorry, I'm a nerd. I can't help it. So, so first, and this I think goes maybe to the question, is a photographer an artist? So first, the court did explain that as a matter of principle, so in general, there are no default rules. So photographs cannot be treated differently from other artistic works. So in principle, it's possible that copyright in a photograph can be infringed in an appropriate case by recreating the scene which had been photographed. Here, the key phrase is inappropriate case. It will all turn on what was the scene, how was it reproduced, how was the original, how was the photograph then, what is the output, the creative choices made. So this is not a general statement, oh, as soon as you take a picture of our Wolfruna building and somebody else does the same, you can sue everyone, okay? So it's not a general proposition like that. But what is then the next stage, no? So then the court explained that whether an artist may have used commonplace techniques to produce a work was irrelevant. That's not what's important. What was important was that such techniques had been used under the guidance of the artist's own aesthetic sense to create the visual effect in question. So it's not how you will, that there's something unique in the way you do the photograph. So, and that's why I think it's important to think that, you know, even with an iPhone, you can create so many different things. And sometimes you go, oh, it's just an iPhone, it's not really a photograph, right? it's not that. So what the court finds important is the artistics, so the artists, the photographers, own aesthetic sense with the aim to create the visual effect in question, so whatever's happening in the photograph. And then they said that in this case, this was an original picture, so an original photograph, which means that it is worthy of protection. So, you know, somebody else coming along, taking this picture, changing it a little bit in the sense of still looking the same. Whether or not that's an infringing copy then rests with the other step that we discussed in the last workshop as well. So I just wanted to mention briefly this iconic London buildings point. So the court said that the fact that it was a picture combining some iconic symbols of London did not mean that the work was not an original one in which copyright subsisted. Okay, so just because you're taking something that everyone knows doesn't automatically rob you of the possibility of having copyright in that. So what is this test that we needed to, so the picture was original, so that's the first step. So it is worthy of protection under the Act. Has the defendants, you've seen the two pictures, has the defendant, so the other party, have they breached copyright? It depends on whether or not what was taken was considered to be a substantial part of the first person's photograph, right? And this is really where the court has decided. So, and I've sort of started with leading sentences. So this action, this reproduction of a picture was infringing because a substantial part was taken, okay? How was that done? So in the end, the issue turned on a qualitative assessment of the reproduced elements. So what was the same? The elements which had been reproduced were a substantial part of the work because despite the absence of some important compositional element, so they were smart not to include everything, they did leave some of the aspects out, they still included the key combination of the visual contrast features with the basic composition of the scene itself. It was that combination which made the image visually interesting. It was not just another photograph of cliched London icons, but you can see how this could be also considered to be just a matter of impression of that particular judge, and yes, of the parties presenting their case. And then, of course, others said, but everyone's taking pictures of iconic buildings. This is really threatening your decision. What did the court say about that? They said the fact that there were other similar works in existence worked against this third party, the defendant, the person that took the second picture, because it served to emphasize how different, ostensibly independent expressions of the same idea actually looked. So it's possible to have the red bus, because all buses mostly in London were red, double-deckers anyway, Westminster Bridge and Houses of Parliament. I have probably, you know, a few pictures myself on different mediums. I'm sure quite a few of us in the audience have those, right? But the way you will present that, and it's a very clear pointing again, copyright protects expression, not the idea itself.
Yeah,
I think, of course, yeah.
Sorry, Metka, to interrupt there. I think Alexis makes a really good point. So he says, I think in this case, it's plagiarism, considering the infringement was done by a competitor. Now, I think that's a really interesting point. Would that be taken into consideration, you know, if they were a competitor? Or like you've just been saying, you know, you sort of take pictures of it for your own use and all of that. Yeah.
The analysis is not who they are. The analysis is what have they taken substantial part. And I know it's annoying, but there's no clear cut. So what is substantial part of what was taken compared? So you compare the two pictures and you say, you know, the similarity, I know that they're not, but that's what was available from the case as reported. So the similarities as they exist and what's also missing and so forth, you know, this, if you compare these two, you can say that there are certain similarities. They're not identical. We can see that it's not the same photograph, but there are also some similarities. And then once you've said yes, it's derived, there are some similarities. The next step is, okay, so let's look at the quality of these similarities. Are the qualities of what has been taken really this personal touch? And it is here that you see, well, actually, everything they've taken is what makes this picture different from any other picture photograph of traffic coming across Westminster Bridge. So it's not because they were a competitor. Even if I had done that, right? Where these issues of competition are relevant is in any defense. So if you're trying to say, oh, but yes, I've taken this photograph, but the reason why I've done it is to actually write a criticism and review report of government's policies around environmental buses. And they persist, despite all the evidence to the contrary, they persist to run these double-deckers, blah, blah, blah. So, you know, it's there, it would matter who I am and how I'm using the photograph. And yes, somebody using this photograph on mugs and making money out of it would, you know, and that's putting them in direct competition of this particular person, that would be relevant there. But in terms of first assessing whether this is allowed under the law, you only have to answer the question, was anything taken? If you take the whole photograph, infringement. If you take parts, or what we also sometimes refer to indirect altered copying, then you need to say, right, let's look at the similarities. And once we've identified the similarities, what is the quality of what has been taken, the similarities? And if those qualities are author's own intellectual creation, are those creative choices, are the expression of this idea, then you have copyright infringement, unless you have some of the defenses available. Yeah.
There's just a comment from James. In my camera club, we have an annual competition, like a treasure hunt, to find the answers to cryptic questions, being a photograph of the answers, as can be found in a particular location, e.g. Stourport. The number of different images of the same answer topic is amazing in terms of differences created by different photographers.
Mm-hmm. So, you know, the courts are not completely off the point then, you know.
Yeah.
And again, if there are specific questions that judges or lawyers would not feel they have the expertise to answer, they would consult the experts. And, you know, that's why parties will often also rely on expert witnesses who will say whether something is done, you know, something is commonplace or something is not, and what was taken from any particular photograph. So there you go. Like I said, the case has been seen as controversial and seen as going a step too far, that this is something that should not be protected under copyright. At the end, it's a red bus crossing the Westminster Bridge, and, you know, just turning things black and white is not really that novel, but that's not what the standard in front of the court was. It was whether or not the combination of all those visual elements was the expression of the author's creative choices. They said it was. I've shown you their reasons, but at least it gives you an impression, right? It's not about you having a fixed answer. It's giving you an example of how a photograph was looked at and how it was found to be original, for something that even, you know, you might think that, oh, that didn't take very long to make, did it? Whether it's a portrait or whatever. Okay. If the two images, I'm just reading from the chat. So if the two images were so similar that you couldn't tell them apart from a distance, then it could be regarded as a copyright violation if it's used to identify a particular brand or product. Branding, products, trademarks, that is a separate area of the law. And I think the point I would take from this comment is to say that indirect copying will not always mean that they are almost identical. It's not possible to distinguish them. So there were cases where you had two fabrics, and, you know, whenever I do that as a surveying class, all my law students go, oh no, they're completely different, and they will start identifying all the differences. But the feel and the impression of the two fabrics is quite similar, even though, yes, you can point to quite a few visual differences. So what is substantial part of the original work does not always mean they are identical or almost identical, if I'm reading correctly. taking screenshots of Zoom meeting. Is that, oh, is that Claire? Fix your hair. Is that from copyright perspective? I'm just trying to see what the question is targeting. Because you will have different questions depending on what you then, you know, if it's for private use, you can basically do whatever you want in the privacy of your own home, right? If you were then to reproduce, so for example, these slides arguably are the property, not property, intellectual property, copyright in the slides themselves. And in my talk, a lecture is a literary work, is with the university, because I'm employed by the university. And arguably what I'm doing now is not that I'm contracted to teach IP to art students, but it's related to my research, right? So it wouldn't be even a violation of my copyright. It would be the university. So it depends really. If I have more details around what is being screenshotted from Zoom, is it the slides? Is it the faces? Because if you just take a screenshot of people attending, there's no underlying copyright. Us as people, we're not copyright protected. If you're taking a screenshot of the slides, it depends what's on the slides. But yes, you know, you might have literary work. So if there are things written on the slides, you might have images as well. Here you can also see you have the University of Wolverhampton. I don't really know if it's registered as a trademark, because I think the university is a charity type organization. But definitely there's some certain symbols that you would also, or you could consider as well. Okay, I shall move on now, unless there is more specifics around screenshots of Zoom. Joint authorship, right? So who do we think could participate in sharing all the profits and control in works that are created? Now, this will be a case that I will speak to around joint authorship between an opera singer and a professional screenplay writer. Okay. But imagine you are taking a photograph, whether it's in a studio or in a specific site or, you know, somewhere, and you have people helping you, giving you creative input. Remember those creative choices we mentioned beforehand. How do you decide? Do you ever think about whether anyone else will be considered to be the photographer or the author of that photograph, right? I'm not going to ask you as to that, but that's why I thought that, you know, at this junction, it would be good just to know a little bit more around rules of, you know, who's the author, and consequently or resultingly from that, who will be the owner of copyright. So first, the author is considered to be the creator of the work. So whoever gave those intellectual creation into the work. So the standard of originality is author's own intellectual creation. If you've done that, you're the author, you're the creator, ta-da, and all the resulting consequences I'll mention in a few minutes. But what if there's more than one person involved in that intellectual creation, right? Now, first rule is it's possible. There can be more than one, right? And there's no limit as to how many. And I know that might not be the case in photography, it might not be the case in fine art, but in music, for example, for so many reasons and practicalities, we've seen, you know, a flourishing of co-authors where you have credits with even 7 or 10 people on a song. And that and doesn't mean it has to be a specific percentage for you to qualify. It can be 5%, it can be 20%. It doesn't have to be 50-50. And also there's no need to sign a contract, together we will. No. So while you're creating, you have this joint intent to create that work. But there's no need to have an intent for you to be joint authors. It's just where your creative minds are focused on. So basically, an author will be anyone who's contributed originality to the work, right? The right expression to the intellectual creation. An example of where people are working towards this.
Metka, we've lost you a little bit there.
Oh, I didn't do anything.
Could you skip back like that, just last tiny bit?
Okay, I'm trying to. When did I zoom out or zone out?
Just like the last couple of sentences, unless it was just my internet. Did everyone else hear that?
That's.
Oh,
I have no idea.
again, losing you again. Oh no, perhaps it's just my internet then. Sorry, apologies. Carry on.
No,
We can hear you.
It might
I
be
can
just
hear
me.
you.
It might be me. Yes,
no, Claire,
it was Claire.
Yeah, no. No, but it's great, Clara. You know, I love having you react with me. That, you know, it also makes me feel human to eventually. So Claire, just what I was talking about is, you know, when you're talking about different percentages and the setup, I was trying to give an example of people working towards the same creative goal, but not being joint authors. If you have, let's say, an edited collection, right? You know, like a research handbook, and you have 30 chapters there, and you have 2 editors. And the editors are working together with the authors of individual chapters. They will not all be joint authors in each individual chapter. The editors of the collection will be copyright owners in whatever they've written. And if you've written a specific chapter, you are the copyright owner and the author of that chapter, not of the entire volume. So that was an example of working towards the same goal, but not on the same output. Okay, so the question, Claire, are you back? I think you've frozen a little bit as well now for a minute. So just let me know if you want me to.
Yeah, I think my internet keeps dropping. So apologies. If it keeps happening, I might leave and come back if it keeps happening.
Yeah. We just have, so the example I was given was a research handbook where you have different authors and 2 editors. So not everyone is a joint author of all the chapters. If you've written 1 chapter, that's you're the author of that 1 chapter, not the entire edited collection. We do have a question, what about the person taking part, i.e. the subject of a portrait, can they be regarded as a joint author? So if they're not participating in the creative choices, then they will not be the joint author. So it all depends on what the joint author does. Let me just maybe give you this example of how the participation of your subject could be judged, right? So the case we've had just now, January 2021, and just it went up to the higher court and then back down, and the final judgment was now just confirmed on the 19th of May, so that's last week. And the case there was something you quite often see, and again, not maybe in photography, but in other areas, things like classical composition in music, actresses, or other performers. You will often have that tension, who's the proper author, and everyone else just sort of pitching in. And the question that was here was in front of the court was whether or not an opera singer was also a joint author of a screenplay that was written by this professional writer. And of course, to make matters interesting is when it first started, they were in a romantic relationship, and then it all went sour, and then they had this copyright dispute as well as to who should be the owner of copyright. And of course, the professional writer M said, well, what she's contributed was just ideas, right? I've actually done the work. So yes, she had ideas and she had tips as we were working on the project, but the final screenplay is my output. That's my work. I'm the author. So how did the court then approach it? They've taken evidence, they've taken at all the different creative stages, all the inputs, they've listened to all the evidence, witness reports, and so forth. And they've actually come to the conclusion that she is a joint author and that her part in this was 20%, which, you know, it's important going forward that any money made from this screenplay, 20% of the profits will go to her. Also, she needs to be asked for permission and she gets all the exclusive rights and everything. So it is an important decision from different, and again, this is from the screenplay sort of environment, but you can think about, so the question around the subject of a portrait. So if it was, the opera singer was being her photograph was taken by a photographer M, the threshold of her creative input would have to match what is said here. So, and that's why I sometimes reproduce the words of the analysis the court did, because I'm hoping that it clicks differently with all of you, depending on how you see your creative practices and what you're used to seeing in the real world. So what happened in this case? So first, the opera singer, she had the original idea for the screenplay. So that's how it all started. The screenplay is actually about opera singers and all sorts of things. And then both of them together set about creating it. So she had the idea, then together they decided to put it in action. It was understood that the writer would have the final say. She contributed to the choice of words and music was central to the film. The central characters owed much to her input, which was in relation to musical feeling and content. Her contribution could not be reflected by pointing to specific dialogue or scenes because it was suffused the whole screenplay. So it was as if her personal touch was all across her screenplay, right? So you can't say, oh, point to the dialogue you've written. That's not the point. Creative choices can be much more, they can go beyond the words. So she made the plot, dialogue and character suggestions based on her feeling for the musicality of the screenplay and her understanding of musical tuition and the world of opera. Her contribution was authorial, so of the right quality. When the final draft was being written, she had much less input, but that was not the reason to stop her being a joint author. So it was doubtful that the parties had agreed to create a work of joint authorship, but that was not required to establish it. So again, let this just serve as a description of what happened in practice. So for our subject in a photograph, she or he would have to do much more than just sit there and say, oh, this is my good side, right? There would have to be much more creative intervention than that. Yeah. And just as a reminder for everyone, so who will be the author? So how long do we have copyright in photographs? So we said already that, not today, but in previous sessions, that how long is copyright? Duration of copyright is for as long as the photographer or the author is alive. If there's more than one author, then as long as the remaining is alive. So if there are two, copyright will not expire until the second of the two co-authors is dead and 70 years after their death, right? So it's a very long intellectual property right? It lasts for a while. And authors are presumed to be the first owner of copyright. It is only owners that have copyright or economic rights. What authors will have is they will have moral rights. And I do have a separate note on the rights given. So there is an exception to this presumption that authors, so if you have authors, they are owners. If you have co-authors, they will be co-owners. The exception is if you are employed, if the author is employed and what they have created is in the course of employment, so it's part of your job description, then the owner of copyright is your employer. So the example I've given you here was with the lecture. That's part of my job. Writing books is not part of my job. So copyright in the book I've written 2 years ago is with me, not the university. Or if I, for example, start singing and, come up with my own EP track or something, that's not part of my job. So that creative output, I would be the author and the first owner of any copyright in the music I've created. It's not part of my job description. Where we see more overlap, and we see that maybe with photographers as well, but there the distinction becomes important. So if you're employed by a newspaper and you're taking photographs for the newspaper, and the copyright will be with the newspaper. If, however, you're a freelancer, then it depends on your contract with them. But freelancers are presumed as authors of the photographs to be the first owners. These presumptions, of course, are just presumptions. They're the starting point. You can, of course, transfer copyright, and we do that by contracts. So you either transfer the copyright, in its entire package. If you do that, that's called assignment. Or you might license the use over your work for a particular duration or for a particular part. So you will say you will license the use for maybe just physical media, just in newspaper, or you will license it for the use online or so forth. So how we will make money or how we will allow other people to interact with our copyright protected works is through contracts. Yeah. With contracts, read carefully and make them in writing. Yeah. Agreements, you will do this because we're friends. It's great if nothing goes wrong, but they're not the most secure way of dealing with these things. Yeah. And I would sort of say if it's not on your radar already, so whenever you are, whether it's work for hire, you're commissioning or anything, have that clause in there, right? That will explain who will have copyright, who keeps copyright, is there a transfer of copyright, and so forth and so forth. So photograph is traditionally protected under the Act, which means there's copyright that is vested into, so there's copyright that exists, and it is just sensible to sort of regulate it expressly, not leave it just in case you will need to come back to the issue afterwards. Okay. Reminders around rights, and again, this is something we've done. The rights portion we've done in last workshop a little bit more extensively. So for artistic works, owners, copyright owners have economic rights. Economic rights over artistic works, including photographs, include the right of reproduction, so making copies. So, whether making a copy is you use it the form print, reprint, whatever it is. If it's a copy of the photograph, it's covered by the right of reproduction, and you need to have the permission of the copyright owner. If that's you, then you don't need to have permission from yourself, but you need to be aware that you have that. So the right to make copies, reproduction, the right of distribution, so to circulate the copies, put them up for sale or sell them. Renting or lending, that would sort of attract now to libraries mostly, because video stores no longer exist. And communication to the public is really the right that is engaged online. So that is a very important digital right. You have that if you are the copyright owner. Okay, so, and we said authors are presumed to be the first owners unless the author has been employed, and the employer will be the first owner. Now, regarding the lecture I've mentioned, yes, the university will be the copyright owner, but I, as the author, will have moral rights. So I have the right of attribution. So I have the right to be named as the author of this lecture. That's why I put my name. Well, not for that reason, but you have the right to be attributed with the authorship of your work, even if ownership of economic rights is with the employer. You still have the right to be recognized for your original contribution. Also, you have the right to object to false attribution. You have the right of integrity, which is very limited in this country. But if there's physical interference with your photograph, so somebody would switch it from a color photograph to a black and white, right of integrity exists. So even if you've transferred copyright by contract, right? So you're no longer the owner of copyright in such a photograph, you still have the moral right to check if the right of integrity has been engaged. So if somebody physically interferes with your work, with your photograph, so alters it, modifies it, and so forth, and there's a separate requirement that is derogatory, so it's offensive to your honor or prejudice, it causes prejudice to your honor and or reputation, then you can stop that. In the UK, these rights are not very strong. They're not giving too much protection. So don't get your hopes up. It exists, but its use is quite limited and reserved to very, very specific cases. And then the right of privacy in photographs that I've mentioned. So if commissioned for private and domestic purposes, there is a separate section in the Act called Section 85, and that deals with what happens if photographs have been commissioned for private or domestic purposes. Okay, so there are more rights attached to that. Okay, so we have a question, right?
Yeah, sorry, from Manos. So let's say I collaborate with a sculptor and we agree to photograph their work in an expressive way, not as a pure documenting manner, whatever that means. I think we know what you mean. We agree that prints for sale will be on a 50-50 basis. Does that make sense, or should there be another balance on the percentage? And then he goes on to just say that he's the photographer.
Yeah. I mean, this is now a question of commercial sense, right? Does it make sense? And that's something that commercially, probably the photographers in the room would be better placed to answer. I think it all depends on the input from both sides. So if this is a collaborative project, you taking a photograph and the sculpture not just standing there, yeah, done it, take a picture, you know, a 50-50 could be a sort of a fair split, but you have to be aware of the fact that you would need their permission anyway, right? Because a photograph of a sculpture can be seen as a reproduction of the sculpture, just it changes the medium. It goes from 3D to 2D. So you need their permission anyway. And from that basis, it's not just your creative input into the photograph that would be important for print sale distribution. It will be also their copyright in the sculpture itself. Yeah, I got it, that it's the sculpture that you would be taking pictures of in a particularly creative way or an expressive. So you try to add a different creative expression to the photographs, not just the reproduction of the sculpture itself. Yeah. But again, it's sometimes, and it's sort of, lawyers would only get a sense of this if they enter into practice around negotiations of commercial contracts. This is very much part of the business operations and business models. And I think artists who are active in the field will be better sort of placed to give you such advice. How do you value your work? How much do you charge in different circumstances? What is a sensible agreement? What I think is a very healthy sign already is that when you are agreeing on what is the basis of the split, and you have a clear conversation around that. Make sure you write it down, right? So that agreement is not only you two discussing it in the studio, but you actually write it down. And then, you know, that will be something you will both be able to go back to once the money starts pouring in. Yeah.
That's interesting, because that example that Manos gave, it made me think about a situation where a friend and I, a friend's a photographer, and he took photographs of my installation, which could also be classed as a sculpture maybe. And I guess you don't really think anything of that because you're sort of mates, but it's kind of one to sort of bear in mind, isn't it? Just in case, I don't know, you don't become friends some way down the line.
Yeah.
You know, we just got a verbal sort of agreement, nothing else.
And it's also, you know, it's not to be too morbid about things, but you know, sometimes you will also, or eventually we will all depart, and copyright can be inherited, right? So, and then even if our descendants, whoever, or our relatives are not interested in making money, they will definitely be interested in preserving your reputation and, you know, what you've left, the creative message. So they would be interested in having that creative control just over what you've left behind. So, you know, copyright from that perspective is the valuable right that artists have to interact with and, you know, to leave behind if wanted, or to commercially exploit or prevent other people from commercially exploiting. I think it's always good to keep this in mind, that yes, it gives you opportunities to commercially exploit if you wanted to, but it also gives you the right of control, because you control the copies, you control the distribution of those copies, you control communication online. These are your exclusive rights. And nobody can do that unless either one of the defenses applies. So fair dealing for private study and research, reporting current events, criticism and review, parody, pastiche, or caricature, or quotation. So very limited uses, and they have to be done fairly. But apart from that, people have to ask you for permission when they want to do stuff with your copyright protected work. And I think that control is also where you do have a creative interest in that aspect of it. So yeah, and I think this is really where most of this happens, right, with maids and everything. But I think with this can easily be sort of, you know, as long as you sort of have that conversation while you're still mates, it's not really going to be a problem. I think where the tension happens is where you have an individual artist and they're dealing with a much larger organization. So either it's a commercial enterprise that says, here you go, I'm going to give you £500 to do X, and then they start using that in advertising or campaign or something. It starts making much more money, and then you're thinking, oh, but I only got 500 quid. Or they've started using it on cat food and I'm not really happy with that, right? So it's those sort of situations where you're negotiating with somebody that's a much larger organization and you don't feel you're in the same equal bargaining position. Or, you know, if it's, I don't know, with larger funders or somewhere where you're really just so happy to get that opportunity that you're perhaps a little bit skeptical around even starting that conversation. But, you know, the first step is really just to know what is out there around copyright, and then have these conversations in the community. Talk to your peers, talk to your friends, talk to your lecturers and so forth. And you know, maybe together you can come up with a sensible best practice as well. But definitely put it in writing, I would say, these kind of agreements. Okay. Shall we just do a few points around online platforms and then leave it for anyone asking questions and stuff? Because the reason why we have a 2-hour session is not for me to blab for 2 hours. It's way not interesting. It's for a more interactive model, I think. So the online platforms, this is where we've seen the UK move away from the EU since Brexit. So the EU has put forward a new copyright directive, a new single digital market directive, and there are specific rules around YouTube and others as well there. The UK did not decide to follow those rules, but what we all have access to is the rules of the platforms themselves. So today we're talking about photographs, right? And that's why I've just sort of focused on Instagram, but the general points apply to any platform you are interacting with, be it Facebook, be it Twitter, be it TikTok, be it YouTube, and okay? When you're posting your own original work on these platforms, usually you are signing your work away in relation between you and the platform. But just read with me just how much and why do I say you're giving your life away or your soul, whichever you find more precious. So what you are, and this is part of the Instagram license. So when you put a picture online on Instagram, you are giving them, Instagram, a non-exclusive. So that means you can give it to others as well. So it's not an exclusive license, but a non-exclusive, royalty-free, so they don't have to pay you anything, transferable. If they want to, Instagram can give this license to other platforms or other businesses, sub-licensable, so they can transfer their license to somebody else as well. Worldwide license, so not just the UK, across the globe. To do what? To host, use, distribute, modify, run, copy, publicly perform or display, translate, and create derivative works of your content. If I was in a legal class, I would say, do you think that is a broad license or a narrow one? But I think, I'm not going to do that right now, but I think you can all see that you're giving a very broad permission for almost anything to be done with the photograph you've uploaded on Instagram. Yeah. And you can see that it says consistent with your privacy and application settings. You can end this license anytime by deleting your content or account. Okay. So yes, so Manos is saying now correctly. Is it Manos or Manos? Claire, you know the correct pronunciation. You said it already.
Well, I did say Manos, and I think that's a
Manos.
thin S. Yes. Okay, that's right. Yeah, Manos.
Manos. Thank you. So it is only in the relationship between the platform and the person uploading. So you and Instagram, unless they have transferred or sub-licensed. So usually what that means is, yes, you're okay between you, me, and Claire, so all the users on Instagram, but there might be businesses that will have benefits of Instagram transferring these licenses to out of it. Can they make money out of it? Is there anything that says that they can't? They can host, use, distribute, modify, run, copy, publicly perform, display, translate, create derivative works of your content. Nothing to stop them. You've given them permission to do all these actions, which they will lose. So you can end this license anytime by deleting your content or account. And we can all agree that that's not really a good option for us. It's more of a take it or leave it. So you either decide that you participate in this thing called Instagram, and you're opening up your online profile, which is your calling card to the world, especially in Corona times, or you lose out on that opportunity because, you know, but there's not, you can't negotiate this with Instagram. Nobody will listen. Okay, so the only protection will be that Instagram will lose everybody if they decide to sell content. You have to always remember that Instagram is all the artistic people and general users and consumers. And, you know, it can vary, and we haven't seen this social corporate responsibility really being kicked out. Okay. Not sure about what, Alexis? If they can make money out of it. Okay, so let me just move on then. So B, about losing, yeah, so I would echo that. Have I any rights if my photo is used to illustrate a cause which I don't approve of? So Jane, you've pointed, so as if you're the author of that, so you've taken the photograph, if you have economic rights, you can stop anyone from using it in relation to a cause, because they're either reproducing it or communicating it online. If it's used and you don't have copyright in it, you might be venturing into moral rights, but those are more difficult to establish. So the best chance you have, Jane, to stop the use of your photo in support of a cause you don't agree with is if you have copyright in that photograph, so economic rights. Okay, so the first point was to remember that when you share things online, you are giving this license to the platform itself. And then the second point is what happens in relation to other users, right? So somebody's already correctly pointed out that, you know, it doesn't mean you can't go after third parties if they've taken a photograph from you. So just because you've given a license to Instagram doesn't mean it's open to everyone to use. So you can still stop third parties using your photographs from Instagram if they don't have your permission. So they will still need other users your permission to use your photographs, unless one of the exceptions applies, and they're very limited in terms of fair dealing. Also, at the same time, just because things have been posted online, don't assume they have all intellectual property permissions. So if you are resharing infringing content, so something that is there's no permission to put online in the first place, you're also infringing. Okay, now for your own materials that you've posted online, if you see that there is an IP problem, you can report it. That's the best way. So don't think about court litigation, don't think about other means. If there's something happening online that is violating your copyright or trademarks, but that will be a separate session. If it's something that's violating copyright in your picture, report it to Instagram. So if you want, I can send you a link, but it's easily Googleable. So Instagram has a IP tool, so to report violation or infringement of your rights. you have two categories. So what right is being violated or infringed, copyright or trademark. And if you click the copyright section, you will then see it will start walking you through all the steps, right? So copyright, and it even explains a little bit. Copyright is a legal right. It protects original works of authorship, such as films, music, books, and art. This form is to be used only for reporting alleged infringements of your copyright. And they're saying that, you know, if you're sort of abusing this right, you know, let's say you were trying to play a prank, or you're just trying to cause troubles for another holder of the Instagram account, you know, you could lose your own account. And then they will sort of say, okay, describe, I'm the rights owner, or blah, 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 blah. So you will go through all the steps. You will also be describing what's the alleged violation, what's happened, which are the rights you have. And, you know, this is a quick process, and they will take down the content fairly quickly. So that's the best and most effective way when you find violations online. Now, what about using materials from others, right? When you find photographs on Instagram, even if somebody will say, okay, this is a picture of my sculpture. If I say that on Instagram, Claire still doesn't know if she can use that photograph, because yes, it's a picture of my sculpture, but have I taken the photograph? So I would have to be very specific with all the descriptions, and then say, okay, yes, she's taken the photograph of her sculpture, and I think I'm fair. So the best way to avoid that, if it's for something, I'm not trying to interfere with people's practices now, it's about finding relevant materials that you might be using either in slides, presentations, blogs, anything like that, that you could, you know, with confidence use online without the threat of, oh, am I violating somebody's copyright? So Creative Commons, and there are 2 points here I want to make. So the first one is, if you're trying to use sort of lawful images online, go to Creative Commons search, and you can see you have 2 types of searches. So the first one is, and I just sort of put there as a starting point, so photography. And all the images I'm using, unless they're screenshots of the actual platforms, I'm using from the CC search. That's how I do it. And then it also gives you the way in which you attribute. So you can tick either use commercially or modify or adapt. If you click below, I want something I can, it will give you all the photographs that you can use commercially, or you're allowed to even modify or adapt. So where does this information come from? Or something you could consider for your own practice as well. And we've done it with the journal, for example. So Wolverhampton Law Journal is gold open access, and we have one of the CC licenses attached to that, so that all of the users coming from outside, seeing that license, can go to the website and say, aha, with everything that this journal is publishing, I can do the following. So there are different types of licenses on the website, so Creative Commons licenses. Again, I'm happy to send the link, but easily Googleable. And these different types of licenses, you have 2 formats. On your, I hope it's on your left, so the one with less text. That's the sort of the one that's meant to be shared with non-lawyers. The content is the same, but it's something you might actually get your head around, right? So the first one, so that's attribution 4.0, so that's the CC license, the international CC BY 4.0. What are you allowed to do? So you are free to share and adapt, okay? The licensor cannot revoke these freedoms as long as you follow the license terms. Now, these licenses explained in these ways, and they also tell you, you must give appropriate credit, and you may not apply legal terms or technical measures that legally restrict others from doing anything the license permits. So the entire scope of permission from the copyright owner is laid out here. What you would do then in practice is you don't attach this to all your photographs. You just refer to it. You can get the specific license. So when you do that online, you will have the reference to your license. You get to choose. So this is just one option. You'll have other licenses that perhaps stop other people from adapting your work, or perhaps stop the commercial use. So you're quite happy with the world using your photographs non-commercially, do what you will. Maybe you're even happy with, you know, the world changing your photographs, as long as that's not used commercially. So you decide as the artist which of the licenses you want to attach, right? You don't have to. So there are two uses here. Either one is that you understand for the images that are put in the Creative Commons search box, that you understand which is the license attached. So there, the terms of these permission, these contracts are very clearly explained. So the one on the right is in legal terms, you can just ignore that. It's the one on the left that's very easily explained. Or you also attach these licenses to your own work, if that's of interest. And okay, so okay, yes, Manus, what happens if someone uses the CC license image in a non-ethical, like some extremists or something? So that would be a question for moral rights, right? So if you have economic rights, you can always stop these uses where you're unhappy with the message that's being associated with your own work. So the economic rights, well, unless you've given the CC license that would allow for the work to, yeah. So if you say remix, transform, and build, so CC license regulates economic rights. What you're left with is moral rights. In this country, moral rights are very limited, which means if there's no physical interference with the work, so a photograph is used as is, you will not really have access to moral rights. In other parts of the world, if there is such a use where, for example, your photograph is used by a group and attached to a message you don't agree with, you can, as an author, have the right of integrity. You have the right to object to derogatory treatment. So that's in other parts, such as Canada and France. In the UK, those rights are quite skimmed, that's quite limited. But you could use, if they do something with it, in addition to using it with a message you don't like. So imagine that you would have a photograph and they've changed the pixelation or they reduced the quality of your work. And on top of that, the context in which they're using it is offensive to you or is something you can't align with morally, then you'll be able to stop them based on moral rights, section 80, the right of integrity. Yeah, Claire, thank you for the licenses link. And with that, I'm coming to the myths again and opening if there's any remaining questions or anything. So you can choose one or two questions and just see if you know the answer. Let me see. So Nina is asking, okay. Nina, yes, you can go to May 4th when we were talking about substantial part. So what remains, so if you're using photographs or images that consist of a larger part, such as collage, what will be important for infringement assessment is whether or first you will look at similarities, and let's say you will say between my collage and that original work, the similarity is that I've used this fraction of the work in my own work, so that will be the same. But then the second step is to assess whether or not what was taken is substantial, thinking about in qualitative terms, thinking about their original input, whether that was substantial from the perspective of the original photograph. And you did mention that it's unrecognizable, so it depends on the specifics. But we did talk about the idea expression dichotomy and the test of infringement, so substantial part. We've discussed that, I think, a little bit last time. On May 4th, there was a recording on that topic as well. Yeah. Claire, how are you with the myths?
I'll put the link actually to that. I'll just find it and I'll put the link to the last talk in there. Yeah, I mean,
Choose one. I'm not going to put the entire list. Do you think you need permission to use copyright works for a school project?
do I think that? For a school project, no. For a school project, no, because it's education.
Yeah, so it's a fair dealing defense for private study and research.
Yeah.
That's why anything you would need to worry about when you're being assessed, whether it's coursework or type of exam for your university stuff, you don't need to worry about copyright, but you might need to worry about Turnitin. I don't know, whatever the examination practices are within the department or within the school. Yeah. But of course, if you're very successful, and I think that was an example I was using in a different context, if you were really successful, let's say you had a photograph which was really marked amazingly well, and then you put that online on your blog, on your personal blog, and you start discussing it, then that's no longer in the context of private study and research. So it will be just assessed as any other use would. You know, the fair dealing defense for private study and research extends only to those uses, not to any other context. We have two more. One is the 8th of June and no, three more. Oh.
3 more. Yeah.
Yes.
I'll
So
put the link.
We have one, and Claire will be kindly putting up the link. So one is coming up on trademarks. So anyone that's running a business, so something where you're either putting products or services in the course of trade, you might be interested about learning, learning about trademarks, so commercial signs for goods and services. How do you register one? What are some of the basic rules? So that's the first one coming up on 8th of June. Then we have another one on the 15th of June, which is now fashion, I believe.
Yeah.
And then the last one on the 22nd of June is music. So they're all touching on specific areas that are relevant to, so the fashion one, for example, will be looking at designs. And it might be that if you're looking at appearance of products as part of your practice, yes, design rights will, in our context, relate to fashion industry, but it's also very important for the car industry, any kind of, you know, design of not just household items, but other products as well. It might be of interest there. So thank you everyone for attending. I do hope that, you know, one of the reasons why, so it works both ways. I also get to learn from everyone sharing their own creative practices or experience from you know, the real world. So I'll tell you the rules and I'll tell you what the approach by the courts was, or if I've learned something from one of your colleagues, I'll pass it along. But it goes both ways, and you know, but with Claire, we can also sort of collect some of the questions, and if they're targeted more at something that an established artist would know, we would find ways also to maybe look at those type of questions as well. So we're quite flexible in you know, how to help with this. Good, thank you everyone. Well, hopefully you'll get in touch, and hopefully this was useful. And Claire, see you soon, right?
Yeah, absolutely. Yeah, and have a lovely bank holiday. Hopefully it's not going to rain, but we'll see.
Now you're just being demanding. No rain in the UK.
I know. Yeah, being a bit hopeful, I think. All right, thanks everyone.
Bye, thank
See
you.
you soon. Bye.